Moncion. Madam Speaker, honorable colleagues, I rise today on the unceded Algonquin Anishinaabe territory at third reading of Bill C-13, an act for the substantive equality of Canada's official languages. Once again, it is my duty in this speech to recognize the colonial nature of official languages and to emphasize the importance of supporting Indigenous peoples in reclaiming, revitalizing, and strengthening Indigenous languages in Canada. We know that the deadline for revising the Indigenous Languages Act is fast approaching. I would like to remind this House, as we did in the report of the Standing Senate Committee on Official Languages, that this Act provides for an independent review 5 years after its coming into force on June 21st, 2019. It will be our duty to exercise oversight and vigilance to ensure that the work is done in accordance with the requirements set out in this Act and, above all, in compliance with the principles of the UN Declaration on the Rights of Indigenous Peoples. More specifically, our report states that, quote, this work must be done in a spirit of reconciliation, of decolonization, and our committee expects the government to meet and exceed minimal legal expectations in respecting the rights of governance and self-determination of Canada's Indigenous peoples, end quote.
Rights regime, as called for in our Official Languages Committee report, cannot be achieved within the restrictive framework of the Official Languages Act. This work requires adequate time and space, as my colleague Senator Cormier and Bill sponsor explained in his speech. In reference to Warren Newman's Senior General Counsel, Constitutional Law Section at the Department of Justice of Canada, during his testimony before our committee. In the context of the development of identity-related legislation, Mr. Newman told us that we must respect the different fields of application and the raison d'être of each act, which shall be interpreted in an harmonious and complementary manner. These principles of interpretation allow me to be optimistic about the future of the Indigenous languages. Official language minority communities will be allies in the cause, knowing full well the role of language in the construction or even reconstruction of identity. We are and will remain in solidarity with Canada's Indigenous peoples.
This brings me to the decline of French in Canada and a justifiable asymmetry. This steady decline in the demographic weight of Francophones in the country has led the government to propose an asymmetrical approach to its reform project. Although this principle has long been recognized in jurisprudence, it could be said that it has always been theoretical or even fanciful in its implementation. A simple reading of this voluminous jurisprudence will reveal the systemic, unequal relationship between official language minorities and the majority in a given province. Inequalities are accentuated when the minority language is French. Alongside the remedial nature and broad liberal interpretation of language rights, the principle of substantive equality is one of the key principles for interpreting Bill C-13's provisions. By proposing asymmetry, the government is attempting to give meaning to the principle of substantive equality between official languages, knowing that the vulnerability and fragility of the French language in Canada and North America legitimizes and justifies this approach. François Larocque, research chair in linguistic rights and issues at the University of Ottawa and a lawyer, quoted in an article published today in the Franco-Presse newspaper. He explains, and I quote, "To achieve real equality, not formal equality, you have to do more for the most vulnerable party." He is convinced, and I quote, that, quote, generic reference to the Charter will not erase more than 40 years of jurisprudence. Principles of interpretation have been established and will not disappear.
Particularly disturbing for Quebec Anglophones who have many concerns and views diametrically opposed to those of their provincial government. I understand their concerns, and I belong to an official language minority community. Provincial policy can indeed be crushing for official language minorities. We must therefore remain vigilant. During the pre-study, our committee received contradictory testimony and briefs on whether or not it would be appropriate to include a reference to the Charter of the French language in the Official Languages Act and in the use of French in federally regulated Private Businesses Act. How, you may ask, do we sort out these positions? It was the other place, really, that decided that question.
The grievances of Quebec's two official language communities took up most of the other place's work, delaying the bill's arrival in the Senate. Passage of C-13 in the House of Commons was highly uncertain for several weeks, but an agreement, 11 amendments, between the Quebec government and the Liberal government broke the logjam. I respect the legitimacy, liveliness, and importance of studying, debating these issues. However, the scope of the debate on the Quebec situation has undoubtedly limited the legislators' ability to pay equivalent attention to the language rights of official language minorities elsewhere in the country. We've been studying this issue for a very long time in the Senate and understand it very well. Fortunately, otherwise it would have been impossible for us to vote on such a bill, which has been the subject of numerous amendments by the other place in less than 8 hours of study in committee. You will understand, dear colleagues, that I am satisfied with Bill C-13 with its amendments. I mentioned this in my second reading speech. However, given the importance I attach to the Francophonie and minority language rights, I must express my disappointment and dissatisfaction with the imposition of a very restrictive timetable for its study here in the Senate. As we all know, the end of session is approaching, and several bills must cross the finish line before Parliament adjourns for the summer. I therefore feel uncomfortable studying in this way a bill that will have such a major impact on official language minorities and on the survival of a language, a culture, and an identity, however plural, diverse, and colorful it may be. Acting as a counterweight to the House of Commons, the upper chamber's mandate is to look after the rights and interests of minorities in regions in the exercise of a sober second look. This work complements that of the lower house, made up of elected representatives, where partisanship reigns.
Discussion in the committee in the other place have sometimes given the impression that the understanding of Canadian bilingualism is no more advanced than it was when Hugh McClellan wrote The Two Solitudes in 1945. I would hope that this notion is now outdated and that we aspire to a less divided vision of Canadian society. By listening to each other, understanding each other's grievances, and empathizing with the most vulnerable groups, we can counter these tendencies towards divisive identity and language politics. Despite this dissatisfaction with the process, I would like to express my strong support for this bill, as its adoption is vital to the survival of our communities.
In 1997, Justice L'Heureux-Dubé, in the Supreme Court of Canada's Lifchus decision, made an eloquent metaphor for bilingualism and minority rights, offering a more unifying vision than McLennan's Two Solitudes. She says, and I quote, "Bilingualism and linguistic minority rights are forever intimately linked, like Romeo and Juliet or Oberon and Titania, and must be presented as a whole." End quote. As I tried to argue at second reading, Bill C-13 is of vital importance to the survival of Francophone minority communities. Canada's bilingualism is a guarantor of the rights of its linguistic minorities. In this more optimistic spirit, I'd like to share with you another observation that appears in the Standing Senate Committee on Official Languages report concerning the Official Languages Act monitoring role. It alleviates the concerns I've just mentioned and is particularly relevant for the future. As the Commissioner of Official Languages reminded us during our committee study, we have a bill that, while imperfect, is very acceptable. The important thing now is for the government to establish an effective and comprehensive mechanism for monitoring this legislation's implementation. This mechanism will allow for compliance assessments of the various provisions of the Act by entities subject to it, and will be equipped with indicators such as the demographic weight of French-speaking minorities and the number of children of entitled persons. This monitoring role will be exercised primarily by the Treasury Board, but also by the Commissioner with the support of Stats Canada and through the Census short form. The OLO Committee will also be able to exercise this monitoring role by inviting the various ministers and departments, as well as stakeholders, to appear before it. This work will enable us to carry out timely follow-ups, report on trends in the demographic weight of Francophones, and the enumeration of children of entitled persons. Colleagues, the work has only just begun, or to put it another way, but this time it's no longer utopian, we have a real chance of success. Survival as a Francophone in a minority situation means constant vigilance, a concern for preserving one's language from one generation to the next, in the face of multiple assimilative pressures in the Anglo-normativity present throughout the country. It may be the absence of a service in French by a reporting entity, but sometimes and often the injustices are more pernicious and prejudicial when it comes to health services and the countless and costly barriers to asserting our rights before the courts, or again when there's a lack of access to the educational continuum in one's mother tongue at home in one's region. On this subject, allow me to quote the Supreme Court's 2020 decision in Conseil scolaire francophone de la Colombie-Britannique versus British Columbia, which reminds us of the raison d'etre of Section 23 of the Canadian Charter of Rights and Freedoms. Quote, school is much more than a place where theoretical and practical knowledge is transmitted. It is also a place for socialization, for exchanging and developing one's language, and through it, for discovering one's culture. It is in this spirit that the right to instruction, one of Canada's official languages, has been given constitutional status by Section 23 of the Canadian Charter of Rights and Freedoms. Sometimes you have to give credit where credit is due. The Senate, and in particular the OLO Committee, whose chairman, Senator Cormier, I congratulate, laid the foundations for this legislative reform. We have succeeded in presenting the structuring principles for legislation that could effectively reverse the decline in the demographic weight of Francophones and improve access to minority language education, which makes me optimistic for the future of our communities and their survival. I encourage you, colleagues, to vote in favor of this bill while recognizing that the process has been imperfect and that, in the future, we should respect the unique role of the upper chamber, which legislates with particular attention to the interests of minorities and regions. In closing, allow me to use the words of Yves Dutaille, singer-songwriter, in his song La Langue de Chez Nous. It's a beautiful language with wonderful words that carries its history through its accents. It's a beautiful language for those who know how to defend it. It offers its treasures of infinite riches. C-13 allows us, as Francophones, to take our place today for tomorrow, to create a better future by mutually extending a hand. Thank you.